Good day! Welcome to Lawyer Up by NDV Law. This is Atty. Nikki de Vega, Managing Partner of Nicolas and de Vega Law Offices. In today's video, I will talk about competition law or antitrust law in relation to tying arrangements. Have you ever experienced a situation wherein your purchase of one product requires you to buy another product? This practice may be classified as a tying arrangement or a tie-in sale, which may be considered a violation of Republic Act number 10667, otherwise known as the Philippine Competition Act or PCA. In fact, Section 15F of the PCA prohibits the supply of particular goods or services dependent upon the purchase of another goods or services from the supplier which has no direct connection with the main goods or services to be supplied. There are no Supreme Court cases at present about tying arrangements in the Philippines. Thus, it may be helpful to refer to the United States and the European Union for guidance on these matters. A tying arrangement occurs when, through a contractual or technological requirement, a seller conditions the sale or lease of one product or service on the customer's agreement to take a second product or service. Tying can be objectionable under Section 2 of the U.S. Act or U.S. Sherman Act of 1890. Although not a formula adopted by the U.S. Supreme Court, the U.S. Department of Justice spelled out the elements of an illegal tie as follows. First, there are two separate products or services are involved. Second, the sale or agreement to sell one product or service is conditioned on the purchase of another. Third, the seller has sufficient economic power in the market for the tying product to enable it to restrain trade in the market for the tied product. Fourth, a not insubstantial amount of interstate commerce in the tied product is affected. Now let's go to the European Union treatment of tying arrangements. Under Article 102 of the European Union's Treaty on the Functioning of the European Union or TFEU, abuse is present when a dominant undertaking makes the conclusion of contracts subject to the acceptance by the other parties of supplementary obligations, which, by their nature or according to commercial usage, have no connection with the subject of such contracts. Well, traditionally, tying is prohibited per se in the European Union. However, with the advent of the cases of General Electric versus Commission of the European Communities, as well as Tetra Laval BV versus Commission of the European Communities, the EU focused on looking at the effect of the tying arrangement and the foreclosure brought thereon. Hence, it was incorporated in the EC guidelines that in order for a tying arrangement to be considered illegal, the following elements must be shown. First, an undertaking is dominant in the tying market. Second, the tying and tied products are distinct products. Third, the tying practice is likely to lead to anti-competitive foreclosure. Well, guided by the wisdom from the US and the European Union, Philippine companies have to ensure that their business schemes do not fall under the category of an illegal tie-in sale. Otherwise, they run the risk of being sued for anti-competitive conduct and be subjected to administrative fines of up to 250 million pesos or worse, imprisonment of up to 7 years. If this video has been helpful, kindly subscribe to our YouTube channel by clicking on the subscribe button. You can also visit our website, ndvlaw.com to learn more about legal matters in the Philippines. Again, this is Atty. Nikki de Vega of Nicolas and de Vega Law Offices. And thank you for watching Lawyer Up by NDV Law.